Hello again, kids. Okay, so I know I'm a little windblown. I had to drive all the way to Albuquerque today because there's no branch of my bank in the town I live in. So that was fun. Yes, this is actually I'm coming to you from Daddy Raven's corner of our bedroom because my office space is out in the middle of the living room, and so there's a lot of kids running around, there's cartoons in the background, and I didn't want to force y'all to hear that. So but anyways, so I started reading this decision by this judge from the Stephen Avery case today, and I gotta say, first of all, I gotta say I didn't get through all of it just yet, primarily because it's just horse shit. I'm sorry, but it is. But how half-ass do you have to be to write a 6-page decision on a 1,200-page motion? Number one. Number two, if memory serves, the motion that they reference in the decision was, okay, so basically, just to give you guys a quick rundown, because I know y'all have been waiting for this video. Okay. To give y'all a quick rundown, this judge made this decision on Kathleen Zellner's motion, and she referenced how a good portion of, basically in layman's terms, a good portion of this motion of Zellner's was reminiscent of another motion that Stephen Avery had entered on his own, pro se, which is Latin. It's a Latin term, but it basically means you're representing yourself. So, but apparently a lot of Kathleen Zellner's motion made the same points that Stephen Avery's motion did. But if I recall correctly, and I could be wrong, but if I recall correctly, Zellner actually motioned to have that motion either dismissed or quashed or something to clear the path for herself to make these further motions. And that's what it's supposed to do. It's supposed to clear the way so that she can amend Stephen Avery's motion. Now, there's other ways to do that. Another tactic that she could have used would file a amendment to Stephen Avery's motion that he filed when he was pro se. That's another tactic. I'm not entirely sure if that's allowed in appellate court. I know it's allowed in some district courts. I know it's allowed in some civil actions. I'm not 100% on if it's allowed in some appellate courts, because despite the fact that we have these appellate courts, which are federal courts, each district kind of operates the way it wants to. I mean, there's some stuff that's static, but some of the more finer details kind of vary from court to court. So she could have filed an amendment. However, she didn't. She filed, I believe, to quash Stephen's pro se motion, eradicate it, and then filed her motion. So this judge dismissing it based off of that make no sense to me. It doesn't. But then on top of that, as though that wasn't enough, let's just go ahead and minimize the camera real quick. We're going to go over here to the decision in order. Pardon my computer, kids. It's a very slow day. It's very rainy in my area today. Okay, so this judge, and I'm not going to read you guys the whole thing, because you guys have eyes, you have brains, you can do this yourself. But okay, so the court has reviewed the second motion brought by the defendant pursuant to Wisconsin Statute 974.06. The defendant offers many arguments regarding new scientific tests that create doubt about the evidence submitted in his criminal trial and alternative theories regarding the case. Additional arguments are offered regarding the competency of the defendant's trial counsel. That's actually typical. When you first appeal, and this was I actually just read about this last night in one of my chapters for sociology. Typically the first motion that a defendant will take in appealing is ineffective assistance of counsel, and it's actually pretty standard. 9 times out of 10, it's it's ruled against. The defendant attached numerous reports to his latest motion, arguing that the forensic tests conducted in the reports were not available at the time of the defendant's trial in 2005. However, this is the part that gets me, kids. The defendant's arguments ignore an important question. Were the tests available at the time of the defendant's previous motion pursuant to Wisconsin Statutes 974.06 or any of the other appeals or motions filed after trial? Now, see, this is where the judge irritates me, kids. This is where I'm getting a little pissy. Because right now, she's nitpicking. That's exactly what this is. She's nitpicking. She's looking to uphold this conviction on a technicality. And that's kind of bullshit. Base, one moment. Yes, we stopped at Whataburger for lunch. Don't kill me. It seems that's a really lazy way of going about this. And there have been a few points throughout the course of this decision that make me question whether or not this judge actually read all of Zellner's motion. Because from what I've seen, she hasn't. If she had, she would have seen a few things. No, the types of forensic testing that was available at the time of the trial are vastly inferior to what's available now. And even if Stephen Avery did file this motion at that specific time, even if the tests were available at that specific time, he couldn't afford it. He was pro se. He didn't have an attorney. He didn't have any money. So yeah, the tests were available. The question was could he feasibly get those tests for himself? The answer to that question is no, Your Honor. The answer is no. Okay? So get the fuck over yourself. Point number one. I gotta tell you, kids, I am itching to get my law degree because some of these judges, I want to tackle them in court. I seriously want to be in front of them because I'm just gonna be like, really? Really? With your great omnipotent knowledge? Really? Okay, so let's keep going through here. In his motion, the defendant asserts that his post-conviction counsel was ineffective for failing to raise these issues in prior motions submitted to the court. A circuit court is not authorized by statute to resolve claims of ineffective assistance of appellate counsel. That's actually true. In this matter, if the defendant wishes to pursue the claims regarding his appellate counsel, the defense may file a night motion with the Court of Appeals. The defendant also asserts that his prior pro se motion filed under this statute should not preclude this motion being heard. The defendant's pro se motion does recognize significant legal issues which the court has previously ruled on. Okay. But see, all right, so kids, and like I said, I'm not going to read this whole thing to you because you have eyes and a brain and presumably should be able to read, although I have that doubt about some guilters. The fact is this. First of all, everybody calm down. Okay, yes, this judge ruled against Stephen Avery. We kind of should have expected that. I expected it. I assumed that all of you expected it. I know Zellner expected it. You can't be in this business without expecting something like that. It went out. I hear my cat outside. She already spent 2 days outside the pendejada, and then I called her in last night, and I guess she must have escaped today when we got home from Budke. Zellner anticipated this. She knew it was going to happen. She already knew. Point number one. Point number two, there are still some steps that she can take in the appellate court in the Ninth Circuit before taking it to the Supreme Court of the United States. There's still some steps. Now, true, the Supreme Court of the United States, getting a case in front of them is kind of hard. They only sit for one session per year, and that's roughly between October, the beginning of October, the first Monday of October, until the session ends, and that's typically late June, early July-ish. And of the cases that are filed in their office, only roughly 70 to 90 of those cases are actually heard by all 9 Supreme Court justices. Like, they actually have a hearing. Very few of them actually make it through. So, it's a little, but in cases of civil rights, more often than not, they'll actually be heard. So, calm down. And actually, if Stephen Avery were to get to the Supreme Court, think of what that could mean for this country, kids. That the Supreme Court of the United States of America is the court that decides policy. Okay? They're the ones who everybody turns to for legal citations and legal precedents. So if Stephen Avery's case were to get to the Supreme Court, that actually could be a good thing for everybody involved, not just Stephen Avery, but all wrongful convictions as a whole. Because at that point, it gives the Supreme Court of the United States an opportunity to set right some of the wrongs that are contributing to these wrongful convictions. Do you see? Okay, so let's move on. On top of that, I would like to add an amendment to this video. Because, basically, it happened. Zellner's not done, and there are more steps to take. So, guilters, while you think that she's down, she's not out. This shit don't end until the fat lady sings, and I'm not about to sing just yet. Not yet, baby. Not yet. So, having said that, I would like to point something out to all of you truthers. My darlings, my loves. Y'all is spoiled. I said this in another video about 2 months ago. Y'all are spoiled. Because here's the thing. Here's what you don't understand. A lot of you weren't around during the West Memphis 3 advocacy. A lot of the current truthers that are Stephen Avery supporters, you weren't there in the 90s when all of us were backing the West Memphis 3. It is a long haul. Writing a wrongful conviction takes a lot of time, money, resources, brain power, manpower. It takes a lot. You're not gonna, just because the conviction came down relatively easily doesn't mean that the overturning of that conviction is going to be easy. There's several factors that come into play, and it takes a lot of time. So just because she was told no once, do any of you honestly think this is the first time that Kathleen Zellner's had a ruling against her? No, this isn't even the 100th time that Kathleen Zellner has had a ruling not go in her favor. It is a long haul sort of thing. It's a long haul sort of thing. And anybody who doesn't believe that clearly has not been paying attention. Okay, the West Memphis 3 case, I remember, I didn't even hear about the West Memphis 3 until, I want to say like 2003, 2004-ish. A buddy of mine, Neil, brought over some pizza and a 6-pack and the video, and we sat down to watch it because he knew that I was like this massive legal fiend, and he brought the original Paradise Lost, and we sat down on the couch and we watched it. So I didn't hear about the West Memphis 3 case until about 2002, 2003-ish. And I gotta tell you, kids, it took another 10 years after I heard about the case, after I was actively advocating and doing what I could. It took another 10 years for those boys to get out, and even then, they're not exonerated. They took the Alford plea, and the only reason they took the Alford plea is because Damien Echols was going to die. Okay? I mean, there's a long haul here, and most wrongful convictions take a long time, from the moment that a decent attorney comes in to actual exoneration or release takes a long time. And for any of you to actually expect Stephen Avery to be out by Christmas or New Year's or Easter or even next fucking Halloween is ludicrous. It's not going to happen. It's not going to happen. Okay? And that's part of the reason why I haven't been doing a whole lot of Stephen Avery videos, is because I've covered everything that is worth covering. And yeah, guess what? There is a ton more that I have not talked about from that case file. But at that point, I'm nitpicking. I'm just how many times can I state that Manitowoc County and Calumet County are incompetent? You know this. How many times can I state that Ken Kratz is a fucking greasy douchebag? You know this. This is not news. This is not something that can affect the outcome of the case. I have stated in over 300 videos all of the points that could feasibly be used to overturn the case. That's all I need to do. And that's what Zellner has done, is she's stated all the points that should lead to a overturning of his conviction. But it's going to take time. Do you think the state of Wisconsin is just going to be like, right, we were caught. All right, let him go. It's not going to happen. We've seen this with Schimmel, with Brendan Dassey. It's not going to happen. Wisconsin has a massive investment on keeping these two men in prison. Why? Well, I'll tell you why. $36 million. If that's what he had the potential of being awarded from one wrongful conviction for a rape, not even a murder, a rape, in 1985, imagine what a jury can and will award him and Brendan Dassey now. Now, and especially with all this publicity surrounding the case. Okay? So the state of Wisconsin has a vested interest in keeping these two gentlemen in prison. And they are going to fight tooth and fucking nail to keep them there. So to expect a quick resolution, it's not going to happen, guys. I'm sorry to say it, but it's not. I have faith. I know that they're going to get out. But they're not going to get out fast. The question is can you hang? Can you hold on for the 10 plus years that it might take? That's the testing of your faith. That is the testing of your convictions. It's not the testing of whether or not it will actually happen. It's a marathon, guys. It's not a sprint. I don't care what Zellner said at the beginning of all this. Okay? Wrongful conviction advocacy is a marathon occupation. It's not quick and it's not easy. It takes time. So, I will leave the link for the judge's decision down below in the description so you all can take a look at this. Don't forget to subscribe to me here on YouTube. Don't forget to follow me on Twitter, Mama Phoenix6. And if you boogie on over to the About page here on my channel, you'll find everything from my Pinterest boards to my Facebook fan page to my Cafe Press merch. Have a very good day and we'll see you soon.